Hi, my name is Stewart, and I'm an attorney in Northern California. My business focuses on business law, estate planning, and intellectual property. Now, today I'd like to talk to you about trademarks. Now, with a trademark, there are basically two areas of law that apply, at least in the state of California, or rather two schemes. One is your common law trademark rights, and the other are your federal trademark rights. Now, common law, what that means is basically what your state law is going to say about your trademark. Generally, that's called an unfair competition law, and that basically means that you start acquiring the ability to protect the mark that you're using when you start using it in commerce. Common law rights, though, are very limited in the sense that they're limited to the geographic scope in which your products or services apply. So that if I start a business in Northern California and I have a certain trademark associated with it, and somebody starts a competing business out in Washington, chances are I can't enforce my trademark rights because at a common law level they don't expand that far. Now that's where federal registration comes in. Federal rights, one of the most important aspects to them is that it gives your mark federal, nationwide, constructive notice of the validity of that mark. And what I mean by constructive notice is that everyone in the nation is presumed to know that your mark is valid, at least for those goods and services that it's registered under. And so that means that you're no longer restricted to your own geographic area. So if somebody starts a competing business on the other side of the nation, you have a legitimate chance of sending them a cease and desist letter and preventing them from doing that, which is a lot stronger right than just being able to stay in your own state, because it can work the other way around. You may think, well, I'm never going to expand my business out of this certain geographic area, so the juice really isn't worth the squeeze for the federal protection. But if somebody else has an idea to use that mark at a nationwide level, and they start using it later than you, it is possible that they could register it and sometime later contact you and say, please stop using your mark. There are obviously more issues that are involved with that, having to do with priority, but the point is that it can cause you some problems. So even if you don't intend on using your trademark registration as a sword, it's a good idea to have it as a shield. So for the $275 it costs for the filing fee of a trademark application, it's usually a pretty good idea to put forward if you're able to. If you have more questions about what's involved in a trademark application or whether or not you can trademark your mark, please give me a call at my law firm or contact me through my website. Thank you.